Actually, somebody is 2002 after the death of her husband. Maybe we should come tomorrow evening or any army get me now.
The second appeal in SA 259 of 2019 and execution cases filed and proceeding about we have filed an IA for the state.
Give your slip.
Much.
From the list. So we have to Mr. Alok Lal at bail for 2 weeks and some cases also.
So if you are praying for 2 weeks time on the ground of Mr. Alok Lal, I think 50% of the cases will be delisted now. How many cases?
Only for admission and hearing.
Orders are there. How many admissions or hearing matters are there? Let us see. 1. How many cases?
Serial number 27.
23 you will argue? 23 you will argue?
Yes, sir.
Serial number?
27.
27 means 26, 27 both gone?
27, 28.
Yes, 27, 28,
31, 32.
31, 32,
40 and
40 and
43.
have you taken consent? Have you taken consent of all the side?
I was taking consent of.
You have taken? What happened to Mr. Alok Lal?
He has gone to Bangalore
For treatment. Click here. It has been submitted that the learned counsel Mr. Alok Lal has gone to Bangalore for his treatments. Full stop. Comma. This prayer has been sought for to adjourn this case for a week, for 2 weeks. Yes, Mr. The opposite counsel appearing for the opposite party have got no objection. Full stop. So you are allowed adjourn for 2 weeks. Yes.
From the list, serial number 9, 12, and 33.
These are orders matter.
All these things are from Mr. Manish Kumar, heading of power station.
These are orders matter. These are orders matter.
I only paper not paper.
No. There is Amit Mishra. Who is Amit Mishra? The serial number 9
Yes.
and
Serial number 9, 12, and 33.
9, 12, 33. 9, 12, 12 is the respondent. And 33. This Amit Mishra is here.
Mr. Manish Kumar is the advocate. Mr.
No, for orders case I will not grant it. When the matters be called on 33, what is the ground for adjourning?
Because Mr. Manish Kumar is out of station, person. He is not here.
First of all, that is not the ground to adjourn a case. There is a judgment of the Supreme Court on exactly on this issue. That out of station is not a ground for adjourning the case.
Because very important. This only for not
33 on the ground of Mr. Manish Kumar. Prayer has been made to adjourn this case. This case is adjourned. Orders case I am not granting time. Let the matters be called over. Yes.
From Delhi courses, under the heading for orders, serial number 1 with serial number 2 with serial number 3, MN number 76 of 15 with MN number 72 of 15 with MN number 77 of 15. Mr. Vijay Kumar Sharma.
Yes, Mr. Sharma, what is this? Serial number? So, what about serial number 1? Use the microphone.
On 23rd March 2021, Your Lordship. I cannot order it, Your Lordship. Consist to the blood center to the expert in 6,23,000. Maybe it corrected number, but it's not.
Which case? Which?
This matter was already was.
Use the microphone. Use the microphone, Mr. Sharma. Yes.
Earlier the matter was heard, Your Lordship. 23rd March.
Serial number?
Serial number 1 and 3, Your Lordship.
2.
1 and
Why 2 has been listed?
Order Your Lordship 23rd March 2021.
Just a minute. MA 72. Yes, this is 72 is allowed. So, what is the other two?
Orders was to place this matter with the records of 72.
Record should be there. 72 did not be listed. How can a disposed matter be listed? Yes, order dated
Order it was 3rd March 2021.
to 23rd March 2021. Yes. Refers to, yes.
The order was there. And was the section of the also for the respondent also, but he has not taken the consideration also, Your Lordship. The matter was not settled, Your Lordship.
So that is over. Why are you showing that? Lok Adalat has got nothing to do with this proceedings. Argue on merits. Argue on merits. Yes. Serial number 1. Case number 76. Yes.
On the ground, Your Lordship, that is what was considered also. As per the evidence, Your Lordship, 7,000, Your Lordship, but the evidence considered the income of the 3,000, Your Lordship. And second, my ground, Your Lordship, which of prospect cannot give me prospect because of the age, Your Lordship.
He was a bachelor. LCR is here. LCR is here. LCR. LCR of case number 22 of 2009. So your dispute is only in respect of income
So my income, Your Lordship, the future prospect
and future prospect.
and my supply, loss of the permission, no problem. Okay?
Let us see. Let us go through the evidence. What is the income? What is your pleadings? And what is your evidence? What is the evidence on the point of income? Let us see. Date of death 2009. Yes.
First, let us say evidence you also Shamla. There is citizen that you can go general from cases.
You go through the evidence. The judgment is already there. You are challenging the finding in the judgment. So why are you reading the judgment? This is an appeal. You are challenging the judgment. You are challenging the finding in the judgment. Controvert it by reading the evidence.
I read the deposition you also.
Yes, you read the deposition.
We have to do your also.
Yes. PW. PW.
PW 2 years.
Come to PW number 1 first.
As years.
Use the microphone, Mr. Counsel. Microphone आगे बढ़ दीजिए तो.
पैरा 3 years. यह कि मृतक रमित लोग चंदन उराम का उम्र 23 वर्ष का था एवं वह दूध का व्यापार करता था। घर में 8 भैंस एवं 8 गाय जर्सी रखे हुए था एवं दूध बिक्री करता था। दूध बिक्री से वह 7,000 रुपया प्रति माह कमाता था। दूध खुलवा एवं कल्याणपुर में बिक्री करता था। लेकिन मृत्यु पैसा दूध और करवा बंद हो गया।
So this is the statement of PW 1. Now you come to the cross examination. Whether there is any question on this issue. Read from paragraph 9 of the deposition. What do you think? Is this the way to argue an appeal?
2 weeks time will be given.
What is this?
Sorry,
What is this? I start hearing an appeal of a motor vehicle case where the claimants are in a dire needs of money, and you lawyers, this is your attitude.
sorry.
What sorry? What sorry? I am sorry for your clients. I am really sorry for your clients. This is the way you serve your clients. That too in a motor accident case, you are for the claimant. Mr. Counsel, I am telling you all know very well this court number 10 and court number 12 and court number 10 is live proceeding. Everyone is watching you, and everyone can watch you after 1 year also. Take your seat. You don't have to argue anything. You take your seat. Let me go through it and let me see what I can do. You don't need assistance now. You are only for assistance. You are only for the purpose of assisting this court. If you cannot do that well, you take your seat. Sorry. Most probably you also don't have any document with you. Most probably you also don't have any documents with you. What do you have to say?
Without any documentary proof, criminal has actually been taken monthly to 3,000.
On what basis? On what basis 3,000? Why not 4,000? Why not 2,000? On what basis 3,000? Why not 4,000? Why not 2,000?
As per our High Court judgment also,
Yes. Yes.
without any document proof, monthly to 3,000 has been taken.
Monthly income of 3,000 is considered for the purpose of computing the compensation when a person is unemployed. It's a notional income. There is evidence on record that he was a milkman having cattle, having milk animal. So first of all, he is not an unemployed. Now the only question is, he claims 7,000. Now tell me, there is a consistent evidence that there were cows and buffaloes, milch cows and buffaloes. Now he was earning 7,000. Have you cross-examined the witnesses on this point? Tell me. You also don't have any document with you. Give this. बोलिए क्रॉस एग्जामिनेशन पड़ेगा जोर से लाउडली. Use the microphone. PW1, read the cross examination. From paragraph 9, from para 9, read.
मुझे बोलखमा का एक की मृत्यु हो गई, दूसरा लड़का की उम्र 23 साल है। जिनका मृत्यु हो गया उनका नाम रविंद्र उराम उर्फ चतुर उराम था। मृतक लड़का छोटा था। बड़ा लड़का 50 समय का होगा। एक लड़की छोटी है, उसके बाद मृतक है, लड़की 20 साल की है। मृतक लड़का का उम्र 23 साल था। मृतक का स्कूल खास मालूम था, 9 क्लास का ध्यान में। स्कूल का कागज देखने पर दाखिल कर सकते हैं।
Continue. There are
मैं भी पढ़ना चाहती, दस्तावेज के नाम पढ़ नहीं सकती। वकील साहब ने ठेपा लगवाया था, मैंने लगा दिया। लड़का का एक्सीडेंट में मरने की सूचना वो दिन बाद मिली। वह बाराती गया था। गाड़ी का कौन ड्राइवर था मालूम नहीं। मैं नहीं कह सकती कि ड्राइवर के पास गाड़ी चलाने का लाइसेंस था या नहीं। खेतिया या लगे को 3-4 खेत 2 बारी है, कट्ठा में नहीं आती। खेती में जीविका चलाती हूँ, घर में और आय का साधन नहीं है। बड़ा लड़का बाहर कमाने गया है।
मृतक कौन स्कूल में कौन क्लास में पढ़ता है नहीं कर सकती। खेती बाड़ी के हम लोगों का जीवन किसी तरह गुजरता है। मुझे का लड़का वो लड़का था, ऐसे तो 2-4 हज़ार रुपये का आमदनी होती। रंग डोरा का शादी ब्याह नहीं हुआ था। बच्चा जब छोटा था तभी उनका पिता गुजर गया था।
फिर यू रीड दैट लाइन अगेन। ऐसे तो
मुझे 6 लड़की व लड़का था। खेती से 2-4 हज़ार रुपया का आमदनी होती थी।
खेती से। यस, देन
गाड़ी युवा की नंबर नहीं बता सकती। कितना युवा का काम चलाता है मुझे नहीं मालूम। ऐसा बात नहीं कि मेरा लड़का जो युवा गाड़ी से एक्सीडेंट में नहीं हुई थी और गलत था।
so far as PW number 1 is concerned, you have not cross-examined in this her on the point of income and keeping buffaloes and cattle. So there is no cross-examination. Now come to 2. You see the chief, I have marked it in this paragraph where he has stated what is the income. The chief, examination in chief, I have marked it. See that it's para 5. So now you read the cross examination.
इसी घटना से संबंधित 4 केस में मैं गवाही दे चुका हूँ। यह 5वां केस है। आरोपी में शामिल नहीं था। मैं मोटरसाइकिल से था घटना के समय।
This is on the point of occurrence, accident. You see what is there on the income. Whether have you cross-examined the witness on the point of income? There is no cross-examination on the point of income. The next witness.
दूध बेचता था। 2-4 गाय था। पालन पोषण उसी से होता था। कितना दूध होता था या नहीं जानता। कौन दूध लेता था नाम नहीं जानता। दूध बेचते हुए मैंने कभी नहीं देखा। कितना पैसा कमाता था उससे हमको मतलब नहीं है। आमदनी के बारे में दूसरे का नाम आपका घर इतना इनकम के बारे में।
But he has stated that I don't know about the income, but he was keeping 2 to 4 cows. And in the examination in chief there is 8 cows. So there is discrepancy. But the fact remains that he was selling milk and was having cows. This is all. Yes. Sorry, Mr. Counsel, I have not got any assistance from you, and I will write it in the order sheet that no assistance was. I have got no assistance from the counsel for the claimant. You have to be sorry. Your seriousness reflects, your action reflects how serious you people are with these type of cases. You think that everything is a bail application? In the corridor I will come and I will. Sorry, Likhe. In this appeal. So, you have got nothing to say. This is the only point which you most probably want to counter. This appeal is directed against at the consent of the parties. This appeal was taken up for hearing, final hearing at this stage itself. Also, next paragraph. This appeal is directed against the judgment dated 26th November 2014, in claim case number 22 of 2009, passed by the District Judge cum Additional Claims Tribunal, Motor Accidents Claim Tribunal number 2 at Chatra, whereby the compensation amount of 2,97,000 has been awarded to the claimants. Full stop. The claimant in this appeal has prayed for enhancement of the compensation amounts. Also, next paragraph. The counsel for the claimant submits that the tribunal has wrongly assessed the income, which is in fact much more, and no future prospect has been given. This is the only submission made by the learned counsel for the appellants. 7. Except this court has received no assistance from the counsel for the claimants. Please take your seat. The next one. The counsel appearing on behalf of the insurance company submits that the tribunal has correctly assessed the income of the deceased to be 3,000, as there was no documentary evidence in support of the income of the deceased. He submits that there are contradictory evidence which has been led by the claimants in support of the income. He submits that when there is no sufficient proof of income, rupees 3,000 notionally is considered to be the income of the deceased, and compensation is calculated on basis of such assessment. It is his case that in this case also the same yardstick has been followed, and thus an amount of rupees 2,97,000 has been awarded. Full stop. Next one. After hearing the counsel for the parties, I have gone through the lower court records and the depositions. Full stop. From the argument, from the submission made by the parties, it is clear that the factum of accident liability, factum of accident, comma, the liability, comma, the fact that the vehicle was insured, etc., is not in dispute. Full stop. The only bone of contention is the income of the deceased and the future prospects in terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others. To assess the next point, to assess the income, I have gone through the evidence led by the parties. First up, be it noted that in the claim application at paragraph 22, at paragraph 22 within bracket D, it has been mentioned that the deceased was aged about 23 years and was earning rupees 7,000 per month from agriculture and dairy farming. So far as evidence is concerned, PW number 1 is the claimant. First up, she is the mother of the deceased. In paragraph 4, 5 and 6, she narrates about the income of the deceased. She states that she had stated that the deceased was earning 7,000 per month by selling milk, as he was having 8 cows and 8 buffaloes. She further stated that after the death of the deceased, the business of selling milk has been closed, and some of the animals also died, as they were not being maintained. First, in cross-examination, surprisingly, no question was put to this witness to controvert this submission. Thus, the statement of the claimant on the point income goes uncontroverted. PW number 2 is Shyamlal Mahato, who stated in paragraph 3 of the deposition, in his deposition, that the deceased was earning 7,000 per month and was having 8 cows and 8 buffaloes. In cross-examination, not even a single question was put to controvert the aforesaid statements. First. PW number 3 is on Prem Moram, who only stated that the deceased was earning 7,000 rupees by selling milk. First. In cross-examination in paragraph 7, he stated that the deceased was having 2 to 4 milk cows, MILCH, milk cows, full stop. On a further question, he stated that he is not aware of the income of the deceased and he also had no concern with the same, as he has got no concern with the same. First. Next slide. The aforesaid statement are the only evidence which has been led by the claimants on the point of income of the deceased. From the aforesaid evidence, I find that the deceased was earning from selling milk is not disputed. He was having buffaloes and cows is also not disputed. The claim that the deceased was earning 7,000 per month has also not been disputed or questioned. First. Thus, in view of the aforesaid positive evidence, the tribunal could not have concluded that the deceased was earning rupees 100 per day, that is 3,000 per month, which is normally considered as a notional income. First, the concept of notional income could not have been imported in this case when there is a positive evidence that the deceased was an earning member of the family. Thus I hold that the finding that the deceased was earning 3,000 per month, thus I hold that considering the income of the deceased as rupees 3,000 per month for the purpose of calculating the compensation is not based on any evidence and is rather against the evidence led by the parties. First up. Thus this court holds that for the purpose of calculating the compensation, the income of the deceased is to be considered to be 7,000 per month. Next one. After going through the award, I find that yes, no future prospect has been granted, Mr. Counsel.
Future prospect already has been given also.
Where is it? Show me. Where is it?
Page number 8, in general.
Yes.
The deceased who are self-employed person or person with fixed wages, the actual income must be enhanced by 50%, where there is not below 40 years.
Okay. Further, I find that 50% of enhancement was granted on account of future prospect, but the same 50% was on rupees 3,000. In terms of the judgment of the Honorable Supreme Court in the case of Pranay Shetty and others, in the age group of the deceased, as he is self-employed, 40% enhancement needs to be granted. Thus this court holds that the deceased is entitled, the claimant is entitled for an enhancement of 40% on account of future prospect. since the deceased was a bachelor, 50% of the amount has to be deducted on account of personal expenses. First, a further 70,000 has to be added for conventional head. So, considering what has been held above, and after making fresh calculation, the amount will come to calculate the zero. Okay? First step. Next para, the tribunal has granted how much interest? Interest. No interest has been granted by the tribunal. Thus I hold that the balance amount thus I hold that the claimants are entitled to get an interest at the rate of 7% per annum on the awarded amount. You have paid the amount?
No, sir.
On the awarded amount of 2,97,000 from the date of filing of this application, filing of the claim application till the date of the award, that is 26/12/2014, and interest at the same rate, that is 7%, on the enhanced amount from the date of the award, that is 26/11/2014, till the balance is paid. Full stop. The interest should be calculated by the insurance company and paid along with the balance amount within 12 weeks. With the aforesaid observation,
One crore multiplied as the age of the deceased, your lordship,
so far as the multiplier is concerned, ऊपर लिखिएगा, since the deceased was aged about 23 years and not 25 years, the multiplier of 18 has to be applied, and not the and not as per the age of the parents of the deceased. 18 multiplied से कर दीजिए. Yes. Next. Yes. Please here. Yes.
state by the lawsuit is on continuous the service sellers and income 7,000 euros. For the witnesses, there is a lawsuit by the service seller. The income of that is 7,000 and consider the income of 3,000. Second long is the vernacular consider the multiplier and the age of the parents also. So age of the receiver also. And the might third row goes to the conventional and also losses then that is not possible conventional and interest losses the conventional interest is 10%.
Yes, what do you have to say? Yes.
CW is elder brother of the deceased.
Yes.
He has stated that his brother has studied up to class 8 in Assam government school and used to attend school daily also. He is a student है.
Para.
Let's see. Para 11.
पढ़िए.
Para 11 second page also. The product case of the claimant is that deceased was earning ₹7,000 per month from his cultivation and vegetable selling. Charlie Dev CW1, mother of the deceased, regarding his profession and income, she has stated that her son used to earn 200 from his cultivator and vegetable selling business. He was unmarried. Her husband is a cattle raiser. Further, she admits that she has stated about income of her son on speculation. CW4 is father of the
PW, you are saying PW2.
CW2 lot. CW2 is elder brother of the deceased.
Rajesh Rao. See, in paragraph 9, he said that he was reading, he left the school and then he was in the business. He was selling vegetables. Take out. Have the counsel for the petitioner, have the counsel for the state. And the petitioner same होगा अपना. इसका argument भी same होगा. After hearing the parties, I have gone through. There is no dispute in so and so. इसमें पहले इसमें कर दीजिए. From the evidence, PW1 is the father of the deceased, who stated that the deceased was selling vegetable and was earning 7,000 rupees per month. So this point was this statement was confronted, wherein in cross-examination he stated that the deceased was earning 200 to 300 rupees per month. PW2 is the brother of the deceased, who also stated that the deceased was earning 7,000. But stated full stop. He also stated that after leaving school, he used to sell vegetables, as the family of the deceased had lands where vegetable was being cultivated. So these are the only evidence which has been brought on record to substantiate the earning of the deceased. From the aforesaid evidence, I find that the deceased was not unemployed. Full stop. Then put in that paragraph, unemployment level. Full stop. 3,000. Thus, from the evidence led, I find that the deceased was earning rupees 5,000 per month, which is evident from the statement of the father of the deceased, who said that the deceased was earning rupees 200 to 300 per month per day. Full stop. Thus, this court holds that for the purpose of calculating the compensation, rupees 5,000 per month should be considered as the monthly income of the deceased, who was a bachelor. Full stop. Thereafter, multiply 18 and the age group, future prospects, and the multiply 18 on the basis of the age of the deceased, not the parents, and 70,000. Calculated interest, same.
Serial number 4, MA number 441 of 50, Mr. Arvind Kumar Lal for applicant, Mr. GC Jha for the respondent.
Use the microphone. Who is respondent number 1?
There were 2 vehicles involved in this case. On the register case,
The counsel appearing on behalf of the applicant submits that the respondent number 1 has expired. Full stop. Considering the said submission, this case is adjourned. How can I grant you time? Statute grants you time. Who am I to grant you time?
Serial number 5 with serial number 6, MA number 493 of 15 with MA number 495 of 50, Mr. Alok Lal
Yes.
for applying both the cases.
But here, notices were issued on respondent number 3, and service report has come that respondent 3 has died.
Counsel for the appellant submits that the service report suggests that respondent number 3 is dead. He prays for some time. This case is adjourned for taking necessary steps.
Serial number 7, MA number 583 of 50, Ms. Nisha Thakur, Ms. Mantana Bharti for the appellant.
How many days? How many days? 90. What is the other side? Who is appearing for the claimants? Notices were not issued. What is the ground? What is the ground? What is the ground in the main appeal? it's a case of death or injury. Is it a case of death or injury? So what is the age of the deceased? He was a gratuitous passenger. Issue notice on the limitation matter of the main application also requisites 10 working days, both process, ordinary process. List. Rock list.
Serial number 8, MA number 72 of 60, Mr. Alok Lal, for appellant, Mr. Asanu Banerjee, Mr. Satish Kumar, for the respondent.
Regarding paper publication has been signed.
Publication of notice upon
Respondent number 7 and 8.
respondent number 7 8. You are appearing on behalf of one? What about the other? What about the other? 2 to 4, they are your son and daughter, minor. Yes? Who will argue? No. It's only for limitation. I will not adjourn these cases for hearing and limitation application. Further counsel for the appellant. Full stop. Next paragraph. The notice upon respondent number 7 and 8 has been published in the local newspaper Prabhat Khabar, which has got wide circulation. Full stop. In spite of service of notice, respondent number 7 and 8 has not appeared. Full stop. The service is the service is taken to be valid, is accepted as valid. Full stop. Next paragraph. I have heard the counsel for the appellant in the IA. Full stop. There is 52 days delay in filing this appeal. An application has been filed to condone the aforesaid delay. The grounds have been mentioned in paragraph 4, 5, 6, 7, 8, 9, and 10. First step, I find sufficient ground has been shown to condone the delay. Delay condoned. IA allowed. Let's discuss another hearing for admission.
Serial number 9 with serial number 10, MA number 191 of 16, with MA number 575 of 50, Mr. Manish Kumar, for appellant in first case, Mr. Sudhir Kumar Sharma, for appellant in second case.
Yes. Why it is under the heading for orders?
Two applications, one for substitution, another for deliberation. My friend has also filed an application.
Who has died?
The appellant number 1 and 2 is also.
Appellant number 1 and 2.
Yes.
Take out. You have no objection?
No. I also filed one Ali.
Take down IA number
In my case, it is
5889.
5888 and 5888 and 5889.
Take down IA number 5889.
5888.
5888. First is for 5888.
Yes, that is sufficient. And it is 9.
Five triple eight of 2021. This IA has been filed to substitute the deceased appellant, namely Gurmeet Kaur, and
So when the thing died off, first
namely Ravinder Singh. Who is Savinder Kaur?
Savinder Kaur is your mother.
Mother of the deceased.
This Ravinder Singh's mother. And the deceased who died in the accident, he was unaccident.
Who died?
That is Ravinder Singh. And the appellant is Rashid Kaur.
Who is this Indrajit Kaur?
Gurmeet Kaur is Rashid is the daughter.
Just give me the who is the deceased? Who is the deceased?
Deceased is Rashid Joginder.
Joginder. Now,
And Ravinder is the Ravinder and the Savinder is the their appearance. Now they are.
the deceased is Joginder.
Yes,
That is the wife of the deceased.
Yes.
The appellant number 1 is Savinder Kaur, that is wife of the deceased.
Wife of this.
And appellant number 2 is the
Is the son of this.
son of the deceased.
Yes.
And what is this 13B of the Hindu
Yes,
market?
what had happened, that this Ravinder Singh her wife and they have taken mutual life.
Who?
And after that, it was an agreement between them that was come in the order that one daughter wants to be included in this proceeding. She will be with Ravinder and another one with his mother. So we have prayed in Marathi to include Radhika and Gurmeet, the father of President Ravinder as a wife.
Now, who is dead now?
Both are.
The wife is also dead and the son is also dead.
The divorcee wife, I don't want.
Wife of the original deceased.
The wife of the original deceased is dead.
Yes, yes.
So
and
this-
her son is also dead.
So far as Savinder Kaur, her name has to be expunged.
Savinder Kaur dead and Ravinder Singh dead.
So Ravinder Singh has divorced his wife.
Yes, that was. And there were two minor daughters. one has become major, and she has, I have filed her wakalatnama also for the among this petition. And another one, if she is minor, she resides with the Wasifa. That I
So she also has to be made a party.
Yes, that paragraph I have mentioned, Your Lordship may include her also. I as per the law. That's why I have given the details. But I have the wakalatnama only with the of the daughter Gurmeet Kaur and one daughter Kanish.
How many daughters are there?
Mother?
How many daughters are there?
There were two minor daughters of that Kanish.
So you have filed this for substitution for both on behalf of
I
both.
have filed for one.
File another one also.
But those are residing at Bharatur, but I am not in that. I have stated the marriage. You lost my marriage. You lost my kindness in my petition. But para file my kindness.
No, include the other daughter of Ravinder Singh.
If she may have done one thing identified in the she may be included as a former respondent for this bill. And her status will be also as an
It's Kanika Sajde. What is the name? Kanika Sajde.
Kanika Sajde and five of us.
And one is Jasprit Kaur.
Jasprit Kaur.
You should notice to Jasprit Kaur, the minor daughter of late Ravinder Singh.
Being
represented to her mother and natural guardian Indrajit Kaur. The address mentioned in paragraph 2b, subparagraph 2b of paragraph 5 of the substitution application. This order will be in MA number 575 of 2015. Requisites to be filed by the claimants within 14 working days. Yes, in both substitution, in the substitution application, filed in the substitution application. Letter appeal.
The first case is 191 to 16. That is also there for me.
Wait. Letter appear in this case? Yes, she is entitled. Letter appear with it.
Serial number 11, MA number 206 of 16. Mr. Vimas Sinha for the applicant. Mr. Manoj Kumar for vote.
And Mr. Sharma. Mr. Sharma, be ready with the 13B divorce degree also. Keep the 13B divorce degree also with yourself. Keep the divorce degree also with you.
Yes, but in the divorce degree it is there for the one daughter.
Keep it with you.
Yes.
It is only for the guardianship. Who will decide with who?
Yes.
Keep it with you. Yes.
Serial number 11, MA number 206 of 16. Mr. Vimas Sinha.
Mr. Vilas Sinha has just instructed the state and has already given no objection to the client.
Who has given no objection? Who has given no objection?
Mr. Vilas Sinha. Now he is appearing on behalf of the
Who will appear? You will appear.
Mr. Alok Lal will appear.
Have you filed your wakalatnama? What is your name? Mr. Shantar Kumar pays for some time to file wakalatnama on behalf of the appellant. First of all, he submits that he has received instruction to appear on behalf of the appellant. Thus, I have full stop. A prayer allowed in this case after 2 weeks, 4 weeks, 3 weeks.
Serial number 12, with serial number 13, with serial number 14, 15, 16, 17 and 18. MA number 248 of 16, with MA number 249 of 16, with MA number 250 of 16, with MA number 251 of 16, with MA number 254 of 16, with MA number 255 of 16, with MA number 256 of 16. Mr. Nikhil Ranjan for appealing in all the cases.
Your Lordship, in this case, respondent number 2 passed away as per the last office note. When the notices were served, it came that this
One by one. We are taking what case, each case is at a time.
It is same thing. Same. Respondents are same. Applicants are different.
Oh, so respondent number 2 is dead.
Dead.
We have filed a substitution.
No, Your Lordship. I have traced out the information, the son of the name of the son. So I'll be filing a substitution application.
Counsel for the applicant submits that the respondent number 2 is dead. He submits that he has received the details of the legal heirs and will take appropriate steps. He prays for 2 weeks time. Prayer allowed is this all these cases after 2 weeks.
Serial number 90, MA number 391 of 60, Mr. Mohammed Kaisar Alam, Mr. Shakil Ahmed, for the appellant.
Why have you to serve the copy of the insurance company? Oriental? Who is appearing on behalf of Oriental? Who is appearing? Who is the lawyer who normally appears? You will appear. Why this case has been listed for orders?
When I have been filing this.
For what purpose? IA for what purpose?
For order 21,
IA number?
21 rule 27. My lord has directed in this case, and it was earlier filed in the form of supplementary affidavit. The lordship has directed that form the proper form.
What do you want to bring on record?
For the exhibition of the validity of the driving license. In this case, the appellant has been right. And
Okay, I understand. Serve a copy. Mr. Keep going. You will be filing Wakalatnama? Mr. Santosh?
Mr. Alukla.
Mr. Santosh Kumar, on behalf of Mr. Alukla, submits that a copy be served upon his office. Full stop. Thus I direct next paragraph. The counsel for the appellant will ensure service of copy of the entire application along with the award in the office of Mr. Alokla within 2 weeks. Full stop. Further, let name of Mr. Alokla appear in the cause list as counsel appearing counsel of the respondent insurance company. Full stop. Next line. The insurance company is directed to file a rejoinder to the IA number 8076 of 2019. Come prepare with the latest judgment under order 41/27. Day before yesterday there is a judgment of the Honorable Supreme Court. Friday most probably, Thursday, Friday. Exactly on this issue. Yes. Next.
Serial number 20, MA number 543 of 60, Ms. Suchitra Pandey.
Serial
For the
number?
appellant.
20. Yes. The appellant will take steps in terms of the office note dated 15/2/2022 within 14 working days.
Serial number 21, MA number 553 of 16, Mr. Atanu Banerjee.
Lordship, I am appearing on behalf of Atanu Banerjee. I pray for short order because he is in relation to number 3.
Why this case has been listed today? Why this case has been listed today? You don't know. What is your length of practice? What is your length of practice? Only 2 years. So these cases are listed under the heading for orders. You don't even know that you have to go through the order sheet and see why this case has been listed for orders. What are the defects? Sorry. Who is respondent number 2? Who is respondent number 2? Who is respondent number 2? Open your brief and see who is respondent number 2. See the award and you see the first page of the brief and tell me who is respondent number 2.
Anil Gupta. Respondent number 2 is Anil Gupta.
Which case you are arguing? What is the case number which you are arguing?
MA 553.
MA 553. Now see the, come to page number 2. Who is the respondent number 2?
Yes, that is Indians. Next page. Mr. Gopal. Sarjula.
Sarjul Ansari. Now go through the award. Come to the award, imputed award, and tell me who is this Sarjul Ansari. Who is this Sarjul Ansari? Tell me.
Sarjul Ansari is the son of Computer Usman Ansari and dependent father of British.
He is the
son of Computer Usman Ansari and dependent father of British.
dependent father of the deceased. That is the appellate. You were right earlier. The defendant is Anil Gupta. Who is this Anil Gupta? Tell me.
Anil Gupta is son of
What is in which capacity he has been made a? He was made a party in the compensation case. Go through the award. Now Anil Gupta you will find. Go through the award. Where is the award? Which page? What is the award? Do you know what is an award? Where is the award? Where is the award? Find out from your brief where is the award. Page number 3. Where is page number 3? 3 cannot be award. Yes, someone please help it. Please help him to find out the award. Mr. Ghosh. Your senior doesn't allow you to touch the brief or what?
Page number 43.
Page number 43 is the award. Now tell me, in which capacity is this Anil Gupta been made a party? Most probably is the owner of the vehicle, the insured. Yes, Mr. Ghosh, is the insured.
Second.
Now, any liability fastened upon him or the right to recovery given? No.
No.
It's not given.
No.
So it is not necessary to issue fresh notice to him.
No.
Take down. I have perused the office note. You have to go through the office note every day, take up the file and go through the office note and understand why the cases are being listed. I have gone through the office note, full stop. The office note suggests that the notices upon respondent number 2, which were issued, has not been served as yet, as the undelivered registered cover nor the AD has been received. Full stop. From the order sheet, I find that notices were issued on 28/2/2020. Next paragraph. Further from the next line. Further from the award, I find that the OP number 2 is the owner of the vehicle, that is the insured, and the award is not against him. So no right of recovery was.
This seems to be under the motor vehicle act, seems to be
Award is against jointly. No order has been passed against him. Against him. In fact, the direction was upon the insurance company to pay the amount of compensation. Thus, this court full stop. Thus, this court feels that no useful purpose will be served in issuing fresh notice upon the said owner. Rather, it will delay the entire proceeding. As this appeal is by the owner, praying for enhancement. Full stop. Be it noted that the counsel appearing on behalf of the insurance company has appeared. Full stop. Is this case under ready for admission?
Yes.
Call for the lower court records. Lower court record is here or not?
No.
Call for the lower court records. Go through the files. Otherwise, you will cut a very sorry figure. After 2 years of practice, I don't expect this type of assistance.
Serial number 22, MA number 309 of 19, Mr. Arvind Kumar Lal for the appellant.
Yes. Where is Mr. Lal? You are on behalf of? You are on behalf of? Please use the microphone because of this glass barriers. It has become very difficult to. Why this case has been listed today? Under the refer orders? Is this case? I'm dismissing this. What will you do? By way of last indulgence, list this case after 1 week. Under the heading for admission. Under the same heading. Under the same heading.
Under the heading for admission, serial number 23, MA number 524 of 15, Mr. Alok Lal, for the appellant.
In this case, Lordship, and service report has come. Respondent number 5, written answer. Respondent number 6, awaiting service report. And respondent number 8, written answer.
If you argue on merits, let's see. You are the appellate insurance company. What is the ground?
Kindly see page number 8.
8.
Page number
8, yes.
Keeping in view the documentary evidences as produced by the Insurance Company Limited, I do not have any hesitation to hold that in the present case, driver of the vehicle bearing number WP 374085 was not having a valid driving license. Hence, in the present case, insurance company has got right to recover the above compensation amount which he paid to the claimant from the owner of truck number such and such, according to the issue number 7 is decided in favor of the insurance company.
Yes.
But right of recovery is not in operative part.
So if the right of recovery is not there in the operative part, you invoke 152 of the CPC. I have already passed an order. The appeal is not maintainable. You invoke 152. What does CPC 152 says? There is a finding. There is a finding and a specific order that it will be you are entitled for recovery. But inadvertently missing the award portion, it has not been mentioned. Yes, Mr. Ghosh, what do you want to say?
The last week, my lord has already.
It's 152. But why an appeal? It's an inadvertence.
Yes.
Yes. What do you say?
Lord, I am for respondent number 1 to 4.
Yes.
He has received the amount.
Yes, what do you have to say? You are for the owner.
No, I am not a driver.
Driver. Sure. Likhito? Take out. The appellant has filed this appeal against the judgment and award dated so and so, passed by so and so, so and so. Only on the ground that though while deciding issue number 2 in paragraph 8, the tribunal has specifically held after adjudication that the insurance company has a right to recover and can recover the amount and right to recover the compensation from the owner of the truck WB 374085. Yet in the award, inadvertently, the aforesaid finding has not been incorporated. He submits that this inadvertence may be corrected. First up. On this ground, the appeal has been filed. Only on this ground, the appeal has been filed. First up. This court feels that the appeal is not the appropriate remedy. This court feels that the appeal under section 173 within bracket 1 of the Motor Vehicle Act of 1988 is not the appropriate remedy in these cases. First, the appropriate remedy lies in section 152 of the CPC, which reads as follows. First, it is the admitted case of the parties that this is an inadvertent error which crept in the award. First, as per section 152 CPC, these type of mistakes, this type of errors, which is accidental or slip of, which is an accidental slip or omission, can be corrected. First, this court in MA number so देख लीजिएगा last week has, in a similar circumstances, has held that if there is an accidental slip or omission, the same can be corrected by invoking section 152. Full stop. This case is covered by the aforesaid order passed by this court. Full stop. Thus, I hold that this appeal is not maintainable. Full stop. The appellant will be at liberty to file an application under 152 of the application under section 152 of the CPC, bringing to the notice of the court the accidental slip of the error which occurred in the award, keeping in view the findings of issue number 2. This appeal is thus disposed of. So the statutory amount to be refunded to the insurance company.
Serial number 24, MA number 262 of 16, Mr. Idrit Sinha, Mr. Vikas Sinha for the appellant, Mr. Bill Bihari Sinha for the respondent.
My only thing was not half more. The only question Mr. Vikas Sinha listens to your lordship. And he's before
Similar this case, similar language before, that the claimant has not been damaged.
Claimant has received the error. Where is the employees' compensation? This appeal will be heard on the following question of law. Whether on the facts of this case, and especially in view of the pleading that the deceased who was working in the electric blast furnace fell ill and he was brought to the medical plant, comma, the case can be said to be covered under section 26, under entry 26 of schedule 3 of the Employees Compensation Act of 23. Or for the doctor. Yes? Wait. Admit. Local record is already admit. Admit.
Admit.
serial number 25 with serial number 26, MN number 279 of 16 with MN number 639 of 16. Mr. Arvind Kumar Lal for appellant in first case, Mr. Abhijit Kumar Singh for appellant in second case.
This is for enhancement. And what is the other case?
Other by the state.
Who is for the state? Who is for the election commission? Yes, what is your ground in the, why have you filed the appeal?
The amount is in excess, Your Lordship, we have filed an appeal against that, Your Lordship. Last day, Your Lordship has asked us to produce some relevant documents, whether there is an MOU between the state and the insurance company or not, and whether the state has raised any claim against the insurance company or not, Your Lordship.
LCR is here?
Your Lordship, I pray for 1 week time, Your Lordship, I file a supplementary affidavit as
Mr. Lal, what is the ground for enhancements?
my ground for enhancement, my lord, that this is was 51 years old, you are senior audit officer.
51.
51.
Yes, what is your exhibit 5 is the salary particulars.
My lord.
Income 27,000 per
Yes.
month.
27,040.
You are saying that is the lower side.
Yes,
Well,
because consortium amount only 10,000 has been given state and this was not given by law and future prospect.
future prospect not given.
Because if it was in government job, then 15% future prospect.
Yes.
Because 51.
It will be 15%.
Yes.
Yes.
For the insurance company, I have been absorbed into that.
How can it be absorbed?
Yes, in the observation because of Supreme Court statement.
Sure.
2008 volume 1 SCC.
2008.
8 volume 1 SCC page 414. Wherein the Supreme Court took into consideration that neither the Parliament by enacting the 1939 Act or 1988 Act did not contemplate the situation where state can be requisition of vehicle forcefully. And thereafter, after discussing all the laws, that held that it is the state who is liable to pay in case of any accident or mishap which has occurred during the period the vehicle was requisitioned.
Okay.
So same full bench judgment of Patna High Court is also there.
Sure. Fill that paper. Where is the judgment of the Honorable Supreme Court in respect to transfer of policy, insurance policy?
It's a recent judgment.
Yes.
That is not wrong, but that will not apply in below section 146(2).
Yes.
But in election, the state elections is not required to
State 146 state is not required to take insurance.
Yes.
But the question is over here, there was insurance.
There was the insurance, but the insurance company has, but considering the usage, whether it is a private policy or the restricted usage, we are undertaking to indemnify.
There was a restricted usage.
Yes. If it is a private vehicle, then you got cheap. And if it is a commercial vehicle, then also there are restrictions. I here got neither the owner has any control who is driving the vehicle, how many persons are boarding the vehicle, and how it is being used. Risk zone is also increased. And therefore, Lordship, para 13, Lordship, of that judgment, Lordship discussed the circumstances, and therefore, after discussing all the judgment in para 19, the Honorable Supreme Court said that now we are of the opinion the state will be liable to pay compensation to the claimant and not the registered owner of the vehicle, consequently the appellant paid. Appellant was the insurance company. Lordship, similar view was taken prior to this. There was a human judgment of Patna High Court also.
So you are not questioning the assessment of income.
No, income was fixed, my lord.
Only the future prospect.
Future prospect and conventional rates.
And the conventional. So yes, what is your ground?
Lordship, we have the MOU, Lordship, between the state and the insurance company, Lordship. I have got a document, but it is not on record, Lordship.
No, it's not necessary. Let me see. What is the immediate? This doesn't help you, it helps them.
There is no need for specific
Endorsement excluding the period. Excluding the period for which the vehicle was requisitioned. So now, what is your appeal is against the quantum? Tell me what is the ground? How it is on the higher side, from the side?
The next gracia sum was paid to the deceased, Your Lordship, amounting to rupees 10 lakhs. That was not adjusted, Your Lordship, by the learned tribunal, Your Lordship.
Whether ex gratia has to be deducted?
Hello?
Ex gratia amount has to be
Ex gratia
deducted.
cannot be deducted.
Where is the judgment?
But ex gratia amount that does not be deducted.
I am asking on what basis you are making this statement. On what basis?
Several judgments of the government, 1990 ACJ case 10 Supreme Court.
Where is the latest one?
By mistake, I have not gone. The date is scheduled of tomorrow, I don't have it. And that's it.
Yes, one ground is ex gratia. What is the other ground?
As said by my senior lordship, the judgment lordship, correct lordship.
So in the course of duty in the election process, किसी का भी एक्शन जब होता है तो एक केस या उसको जेल एक्शन होता है। ये अंडर द मोटर व्हीकल एक्ट जो व्हीकल में चल रहा है उसका कोई नेक्सस नहीं है। That is a separate issue and this is separate issue.
I am asking you. I am asking for a judgment.
Yes, by mistake I want one thing about it. But judgments are there, my lord. If tomorrow or on Monday, my lord, then certainly I will submit the
लिखिए था। In miscellaneous appeal number 279 of 2016, the counsel appearing, the learned counsel appearing on behalf of the appellant submits that the claimants are entitled for an enhancement. He submits that he is satisfied with the calculation of the income, but on the aforesaid calculation, 15% as future prospect should have been added by the tribunal while arriving at a final quantum of compensation. He submits the future prospect has not been granted in this case, and under conventional head, a meager amount has been paid, which is not in accordance with the judgment of the Honorable Supreme Court in the case of Pradesh India members. This is the only limited ground raised by the appellant in this appeal. The MA 639 of 2016 has been filed by the state challenging the quantum. First, the counsel for the state submits that the quantum is on a much higher side. First up, he submits that rupees 10 lakh was granted as ex gratia to the family of the deceased, but this amount should have been deducted while calculating the quantum of compensation which the tribunal failed to do. Next paragraph. In reply, Mr. Arvind Lal submits that the Honorable Supreme Court in several decisions have held that the ex gratia amount paid by the employer cannot be deducted.
Employer or the state?
Employer.
The state is not the employer.
Who is the employer? Who has paid ex gratia amount?
The state.
Election Commission.
Election Commission doesn't pay.
There is a provision of
Election Commission of India has issued a letter to the state. What will be the amount of this ACR payable in case of somebody dies on election? I have filed that complaint. And it is paid by the state. The state
He is your employee.
paid by the state.
He was the employee of, what was he?
audit office.
Audit officer of?
Under the government.
Which government?
State.
So it is he is your employee.
Yes, sir.
By the employee or others cannot be deducted while calculating compensation under section 166 of the Motor Vehicle Act. Mr. Lal submits that he will address this issue along with the judicial pronouncements, for which he prays for some time. So, considering his submission, there is this case next week. Next week.
Yes.
Serial number 29 with serial number 30, MA number 377 of 16 with cross appeal 34 of 21. Mr. Vivash Sinha for appeal in first case, Ms. Rakhi Rani for appeal in second case.
Sir, on behalf of Mr. Vivash, I am praying for short pause. Even if army for the other court not
Passover.
okay.
Serial number 34, MA number 542 of 16, Mr. Sachin Anandas, Mr. Praveen Kumar Chatterjee for appeal, Mr. Ramesh Kumar, Mr. Shekhar Pradhan Sinha for respondents.
Yes. Enhancement.
It is a question. The question is application filed under section 163 capital A. The structure for the basis that is the driver of the tanker met with an accident. The compensation was it is determined on the basis of section 163 capital A 2 reduce second schedule. What is the age? What is the income of the disease? And that corresponding amount is given in the chart. And here he has calculated on the basis of the general principle order
166.
and another part that he divided this amount in two parts on the basis of contributory negligence.
Yes, sir.
163, where is the contributory negligence?
Because certainly because that is structured from the
LCR is here. Call for the local records.
Yes.
The counsel for the appellant submits that the claim application was decided as per section 163 capital A of the Motor Vehicle Act. First, he submits that when the structured formula was followed, comma, the tribunal could not have applied the is the contributory negligence held?
Yes, but it has been apportioned 50% because the other vehicle was not made part. There are 13
There are
13 of the award. Two vehicles involved, that 50% with this.
okay. Could not have Kelvin.
Submit a structure from the quality that could not apply,
Could not have applied the theory of contributory negligence. So, next paragraph. To appreciate the aforesaid fact, let the lower court records be called. Now, by the new act, most probably the structured formula 163 has been deleted.
That has been taken.
That is been deleted.
Has been added 2017 version. In fact, that
2017, yes.
has been taken away.
And now,
But this is the old act.
yes,
Accident
this is the old act. This is the old act. Yes.
Logics are not really well coming. So this was getting mad.
Tell someone to make a mention. Yes.
Serial number 35, MA number 548 of 16, Mr. Abhay Shankar Dayal, or appellant, Mr. Maleshwar Yadav, Mr. GC goes for the respondent.
You are paying 36. Who is for the insurance? 36. Three 31. 330. ठीक है 330. Now where will I send it? National Local Adalat is over. Which district? Dhanbad. When can you bring the check? You asked him to give me list was and directed this case to be listed on 8.3. Why it was not listed?
On 8.3 it was listed, but it was not taken.
You had not mentioned this case on 8.3. You should have mentioned this case on 8.3.
Just one case before the
Okay, Likita. Pursuant to the order dated 28/2/2022, the counsel appearing for the insurance company submits that the insurance company has agreed to satisfy to pay a further amount of rupees 3,30,000 in lump sum to the claimant. Next part. The counsel for the claimant submits that their claimant is ready to accept the same as full and final settlement. Considering this submission, when can you produce it? A check, or it will be given to the court below. Considering this submission, I direct the insurance. I direct the insurance company. Considering the said submission of the parties, this appeal is disposed of in view of the settlement arrived at by the parties. Full stop. The amount of rupees 3,30,000 should be immediately deposited within 3 weeks. Within 4 weeks. 4 weeks, not 8 weeks. Okay, 5 weeks. Within 5 weeks before the district judge, before the MSCT district judge 15 MSCT Dhanbad in title MV suit number 346 of 2014. First up, the tribunal will disburse the amount immediately in favor of the claimants after proper verification. First up. It is further made clear that the claimants will be at liberty to furnish the bank account details along with a cancelled check. No, इसको छोड़ दो. After proper verification, first up, this appeal is thus disposed of. That the parties have resolved their dispute.
Serial number 37, MA number 348 of 18, Mr. Amit Kumar Das, Mr. Anjani Kumar, for the appellant.
In this case, the claim was filed by the mother-in-law and mother-in-law of the deceased claimant. The ground is the election. The same principle which is applied in applicable election for claim being made by the parents will apply in election. And And as per your survey,
Who brother-in-law and
father-in-law and mother-in-law
of the
deceased.
deceased was a lady.
Lady.
What was she doing?
They say she was doing tailoring work.
And she had no son or.
Husband was probably died. I'm not sure was in the same.
What was the husband?
Husband was probably died in the same.
Any application filed with the.
That is not verified.
Verify it. You are the only person who can verify it. I'm calling for the lower court records.
Yes.
Call for the lower court records. First of the counsel for the. He died of the same accident, that is sure.
Actually, it appears because nature of accident is she was traveling with her husband. But it has not come in the journey.
In a motorcycle.
In the motorcycle.
Who was driving the motorcycle?
The husband was driving.
He may just look into it. Call for the local records. Now, what was the husband doing?
That was also not.
How can the mother-in-law and father-in-law be said to be dependent upon this lady? If the husband is alive?
That is another ground.
Maybe the husband was driving a motorcycle and he has met with an accident, the wife died. The fact that he was the owner and the driver of the motorcycle, that has been suppressed. Then what will be the third party insurance? So will the lady, what will be the legal effect?
Because the charge sheet has been submitted against the offending vehicle which was insured by us.
Maybe you just find out what happened to the.
Find out whether there is any.
Yes. Yes, next.
Serial number 38, MN number 287 of 19, Mr. Indrajit Sinha.
What is this case? First tell me, let me understand this.
The suit has been filed by the pension period claiming title millard upon the property. But the injunction was filed and the injunction was rejected against the period that serious fee has been covered. Now, as per the millard,
What is the appeal order?
the allotment has been done and the construction has already been completed.
What is the appeal order?
It's at page 87.
Page
87.
87. Yes. 87. The main application is of 52 pages only. The main application is of 52 pages only. 55 pages.
The complaint has been ended.
This is the main petition which you have filed. It's Arvind Kumar Shah.
Yes.
Yes, sir.
So the main petition is, what is this? Who has typed this case? Files like this. I don't even know how to type the file. The rejoinder is first. Who are this office? Rejoinder on behalf of the applicant to the complaint affidavit is typed first. The suit was filed by Arvind Kumar Shah. Praying for your right title interest.
I'm not ready to be that cancelled. My senior listens to your lordship.
So the stay has been refused. Prayer has been made on behalf of the appellant to adjourn this case. Prayer allowed, this case is adjourned for 2 weeks. 2 weeks or 3 weeks. 2 weeks or 3 weeks?
2 weeks.
After 2 weeks. Where the construction be finished, in the position we do. Construction is finished.
The allotment has also been done. Everything is finished.
Well, an allotment has also been done.
Yes, the civil market is started.
What is the stage of the suit?
The perhaps the issues are quite big there. Because the court are issues, 2 wheeler of 2018 perhaps, not 2018 2 wheeler. Because the 4 wheeler the court was not functional.
Just tell me the date when the pleadings were completed.
That will give the latest publication.
Yes, date-wise. Date-wise when the pleadings were completed and at what stage now the case is going.
Okay, next time.
Serial number 39, MA number 343 of 20, Mr. Rashwar Prakash, Mr. Praveen Akhari.
AET Ashutosh Anand versus Pilot in this present case, Pilot. He is on the executive number 3, just praying for password for few cases, Pilot.
State of Jharkhand. Call it. Call him. In which court? In which court?
In court number 3, so the matter is going on serial number 19.
No, this is that case. Where the DFO has filed that I am not liable to pay, it is the state who is liable. So the DFO is not a part of the state.
That's why we also sought assistance of learned at
Yes. Call him, call him.
just password for the cases. First is both the matter is ongoing, Pilot. Both number 3 laws.
Call him, please, call him.
Sure, sir.
Password. Okay, call the cases for hearing.
Under the heading for hearing, serial number 41, MA number 59 of 50, Mr. Pratyush Kumar.
Yes.
The other side perhaps is here right now. But only for the right of recovery first.
Not granted.
Not granted, but in view of Annexure 1 verse to my written statement, specific defense was taken that the driver was not duly licensed, the vehicle was a truck. But so we kindly see Annexure 1 running.
What is the issue number 4?
Yes, issue number 4 is that.
What is the finding?
License, and that has been determined.
Let's see.
Say, your just come to the issue number at 11 at page 6. There is no evidence regarding the driver's license of the truck driver in the accident. Only in the pleadings insurance companies regarding to one for the issue valid driver's license of driver. Thus, if redundant, this issue is decided by body. If you are read a specific issue, the owner ought to have produced the driver's license. He also appeared to clarify the written statement. Lordship sees clarify. The WS 5 different number 1, owner of the truck number WGP so also. The vehicle in question was insured on national insurance at the time of occurrence, so it came.
Who is for the owner? Who is for the owner? Can see him? Who is appearing for the owner? Owner is respondent number?
Owner is there are two owners, two vehicles. What my owner is Sarja Mirza of the respondent number 5, who is opposite party number 1.
What is the validity of service? SR of respondent number 5 at flag W. So you are praying for recovery against respondent number 5.
Respondent number 5. Shah Sahab is the owner of that WGB 420. Transcribe page 1 so they do the word that nobody argued for the presence of on behalf of movie number 1.
No.
Even though they find WS, it's not really the right license.
Where is the judgment of the Honorable Supreme Court?
Yes, 2018.
The prima facie it is the owner of the vehicle who has to produce the.
Yes, I have to
Para?
13. Since the basic facts have to be pleaded and proved, here what Joginder Singh's driving license was produced, he was not even able to prove that Joginder Singh was driving. But in our case, if anybody was said to be a driver, then at least his driving license ought to have produced. The basic facts need to be.
What is the judgment which I had passed on a similar issue? Yes?
In the case was only insurance company, they have not covered. There are two insurance companies, two vehicles were involved. Head on collision for the negligence half and half a year.
Okay. Heard the counsel for the appellant. Full stop. And you are appearing on behalf of? And also the counsel appearing on behalf of respondent number 7. Full stop. In this case, in this appeal, the appellant hearing, that is National Insurance Company Limited, has challenged the judgment and award passed in case number so and so passed by so and so, only on the sole ground that on the facts of this case, right to recovery should have been granted to the aforesaid appellants. He submits that next further. The counsel for the appellant submits that the owner of the vehicle bearing registration number is Shahjahan Mirza WGB-4204 was insured by this appellant, but the owner did not appear before the court below. The owner did not appear before the court below to produce any documents in respect of the vehicle. He submits that only after filing the written statements, the owner left the proceedings. He has filed WS. Where is that?
Yes, filed WS.
The owner, he submitted the owner only filed his written statement and thereafter did not choose to adduce evidence. He submitted that in absence of the details of the driving license, when a specific plea has been taken by the insurance company that the vehicle was being driven without a valid license, driving license, the right to recovery should have been granted in favor of the insurance company. He submits that the onus was upon the owner of the vehicle to produce all the documents, comma, including the driving license, so that the same could be verified. In support of his contention, he has placed before this court a judgment of the Honorable Supreme Court as reported in so and so versus so and so 2018 volume 3 SCC page 208 Pappu and others versus Vinod Kumar Vinod judgment and basis on this. He submits that since the owner has failed to discharge the initial burden, the insurance company could not have been saddled with the liability to pay the amount of compensation. Rather, the tribunal should have applied the principle of pay and recover in the instant case. After holding that, after drawing adverse inference against the owner of the vehicle. Next paragraph. No one appears on behalf of the owner of the vehicle, bearing number so and so. We'll start from order sheet dated. From the order sheet dated 2/8/2018, I find that the notices have been held to be validly served upon respondent number 5, who is the respondent number 5? Shahjahan Mirza, who is the owner of truck number WGB 4204. Thus, this court is proceeding ex parte against him. Next one. Considering the limited scope of this appeal, as raised by the counsel for the appellate, I have gone through the pleadings of the parties. You are National Insurance. National Insurance Company Limited. Next line. National Insurance Company Limited, who is the appellant here, has filed their written statement before the tribunal.
And I need to words about the question. However, it is submitted that the driving license for driver of truck WGB 4204 road permit fitness and fitness certificate of the truck were not valid and genuine, thereby the owner.
The last paragraph of paragraph 18 of the written statement. In the last portion of paragraph 18 of the written statement, it has been specifically pleaded as follows. Quote inverted comma. However, it is submitted that the driving license of driver of truck number WGB 4204 and road permit and fitness certificate of the same truck were not valid and genuine, and thereby the owner of the same truck has knowingly and negligently violated the insurance policy, terms and conditions, and in the circumstances, this defendant company cannot be settled with liability. Next paragraph. The owner of the vehicle appeared and filed a written statement. In the written statement, there is no whisper about the. Have you got the written statement? In the same written, I have gone through the same written statement. In the same written statement, the owner of the vehicle has not controverted the aforesaid assertion. The assertion made in paragraph 18, last portion of paragraph 18 of the written statement of the insurance company, appellate insurance company. Nowhere in the written statement, the owner of the vehicle has stated about the driving license of the driver. Neither the owner controverted the said statement nor brought any material on record to remotely suggest that the vehicle was being driven by a driver having a valid driving license. The written statement of the owner doesn't contain reference of any driving license, nor even a statement to the effect that the vehicle was being driven by a person holding a valid driving license. He has not laid evidence also?
As per the award you received, there is no driving license.
The tribunal framed an issue which is issue number 4. The effect that whether the drivers of the offending trucks have valid and effective driving license. The aforesaid issue has been answered by the tribunal in paragraph 11 of the above. First, the tribunal has held that there is no evidence regarding driving license of the truck drivers involved in the accident. Since there was a specific pleading of the insurance company that the vehicle was being driven without a valid driving license, by a driver without a valid driving license, and there was no evidence contrary, the issue should have been properly decided by the insurance company, by the tribunal. Next one. Yes. The Honorable Supreme Court in the case of Pappu versus Vinod Kumar Lambar as reported in so-and-so in paragraph 12 has held that the insurance company is entitled to take a defense that the offending vehicle was driven by an unauthorized person or the person driving the vehicle did not have a valid driving license. So it has been further held that the onus would shift on the insurance company only after the owner of the offending vehicle pleads and proves the basic facts within his knowledge that the driver of the offending vehicle was authorized by him to drive the vehicle and was having a valid driving license. Paragraph 12 का mark कर दीजिए. The onus will only upon the aforesaid pleading, only upon the aforesaid pleading, the onus will shift upon the insurance company. First time. In the instant case, I find that the the insurance company had taken a defense that the vehicle was being driven by an unauthorized person, comma, or a person who was driving the vehicle, or by a person who did not have a valid driving license. When this defense was taken by the insurance company, specifically in their written statement, it was the duty of the owner of the vehicle to rebut the same, either by filing an appropriate affidavit or by producing necessary documents. That is, bringing on record the driving license of the driver. First, the owner of the vehicle did not produce any documents. Thus, has failed to discharge the burden. Full stop. Thus, in view of the specific pleading by the insurance company, which has not been controverted or rebutted by the owner, adverse inference should have been drawn against the owner of the vehicle in the instant case. Thus, since the owner has failed to discharge its duty, this court holds that the owner or the vehicle bearing truck number so and so was being driven by a person who was not authorized to do so. Thus, there was a breach of the terms of the policy. Next one. When there is a breach of the terms of the policy, it cannot be said that the insurance company has to indemnify the owner. Full stop. The Honorable Supreme Court, in the case of Papua and others, have referred to the judgment as reported in 2004, Volume 3, SAC 297, that is National Insurance Company versus Swansea and others. First up. Paragraph 110, Roman 3 to 5 of the aforesaid judgment of Swansea needs to be quoted here. Quote correctly. Thus, in view of the aforesaid judgment, I hold that since there is a violation of the policy, the insurance company has a right to recover the amount of compensation from the owner of the vehicle. So and so. But this appeal is allowed only to the aforesaid extent, giving liberty to the appellant insurance company to proceed and recover the amount of compensation from the owner of the vehicle. So and so. Full stop. Next para. Yes. Here, the insurance company is entitled for refund of the statutory amounts are deposited. First of next para. So 50% was only directed to be deposited.
50% was directed to be deposited, and that was also not to be disbursed under instructions party to this fee.
By judgment date, by order dated
31st March 2016.
31st March 2016. A bench of this court directed the insurance company to deposit 50% of the awarded amount with a rider not to disburse the same to the claimants. First off, in view of final disposal of this appeal, you have deposited it?
Yes.
The District Judge 5 Presiding Officer Motor Accidents Claim Tribunal is directed to disburse the said amount to the claimants after proper verification. You have deposited this along with interest or without interest?
The 50% was awarded amount, generally the total cost of the interest.
The interest on this 50% which was deposited is to be calculated from the date of filing of this in terms of the judgment, in terms of the award of the tribunal. The same will also be paid to the claimants. Full stop. The balance 50% along with interest from the date of filing till the same is paid is also to be must be paid to the claimants also at the rate fixed by the tribunal. How much interest amount has been? दिया है कि नहीं दिया? 6%.
6%.
This appeal stands allowed only to the aforesaid extent.
Serial number 42, MN number 95 of 50, Mr. DC Ghosh for the appellant, Mr. Nitin Ranjan.
Yes, Mr. Ghosh.
The issue is
140.
no,
Yeah.
the right of recovery has already been given. In case of cancellation of policy, the appellant is paying for total waiver of the liability. That of the case,
What is the finding?
Internal page number 6 of the judgment velocity
Yes.
the policy was cancelled and that has been discussed. Internal running page 14. Paragraph on behalf of appeal number 2, one witness has come up mainly a sensing procedure is was stated that Governor PRG number 1974 dated 2002 was cancelled on the next day, and the owner as well as the minister as well as DK was informed in this regard. The affidavit says that no premium was taken by the insurance company, and as such there was no existing insurance policy or the date of occurrence. In cross-examination, this witness says that the cancellation letter was sent to the owner, though he says that Governor showed validity from 21 January 2002 to 22 January 2003. In the part that there is nothing significant in this cross-examination. Thereafter, coming on the documentary evidence can certified copy of the file which has it is going to get on behalf of opposite party exhibit A is the photocopy of the later dated 23.
No, how is this? The tribunal has to give a specific finding whether there was an insurance policy or not. The tribunal has not given.
Well, page number 6 we can see.
Page number 7, page number 6, under the circumstances, read from last 3 lines. Under such circumstances, it appears that the insurance company has not been able to prove beyond all shadow of reasonable doubt that the cover note issued on so-and-so was cancelled. On so-and-so. And therefore, at this stage, the tribunal comes to the conclusion that the insurance company is liable to pay the compensation amount to the claimant, subject to the right of recovery from the owner, for which the insurance company shall have an opportunity to sue the owner and get the same recovered in accordance with law if at all there is no valid existing insurance policy. Who will decide whether there was a valid existing policy or not?
So that is what page number 6 itself,
Yes.
in that issue number 7, 8 and 9, right?
Yes.
Second paragraph. It will clarify this point. Issue number 7, 8 and 9 are taken up together for argumentation.
No. Whatever may be there, this discussion. But what is the finding? What is the finding?
The rationale behind this finding will not even find there. Maybe just one paragraph.
Yes.
That issue relates to entitlement of claimant for compensation. From whom and to what extent. Issue number 9 is identical and it has to be seen as to whether the insurance company is liable to indemnify or not. The insurance company has come up with a specific thing that there was no valid insurance cover note issued on 22/1/2002, which was cancelled for it on 23/1/2002. And the documents in this regard have been placed and brought as record exhibit A in this letter of cancellation cover note. Though it has been mentioned that the original cover note was cancelled, and apparently the original cover note has not been produced by the owner, but simultaneously the same cancelled cover note has not been produced by the insurance company. The letter of the insurance company marked exhibit A is on the record. And it appears that the financier has assumed the insurance policy on such assurance. The premium was paid, but the insurance was refused for a technical reason, i.e. vehicle of 1974 May was not allowed to be insured. This is the reason it was returned. On perusal of record, it transpired that no such regulation or circular has been brought on record as to why the vehicle of 1974 May was not required to be insured. Further, the defense taken by insurance companies non-payment of premium, but letters show that insurance was refused on some other ground. There is variation in pleading and evidence. Further, specifically in this regard was not taken while filing the show cause under section 140 of MD Act. And most significantly, if the original cover note was cancelled and taken back as claimed by the insurance company, the same could have been produced before the court, which was not done. So, my submission in this law.
Already a submission. What is the finding?
The finding law, it is that
the issue was kept open. The issue was kept open for a subsequent proceeding.
No. From what I read,
read. And therefore, at this stage.
Therefore, at this stage, tribunal comes to conclude that insurance company is liable to pay the compensation amount to the claimant, subject to right of recovery from the owner, for which the insurance company shall have the opportunity to sue the owner and get the same recovered in accordance with law. So,
read thereafter. Why are you stopping?
Law. If at all there was no valid existing insurance policy.
So the court has not come to a conclusion as to whether court was also not sure whether there was an existing policy or not. So just a minute. What was the duty of the tribunal? To come to a specific finding whether there was a policy or not? Can the court give this order that get the same recovered in accordance with law if at all there was no valid existing insurance policy? Whether it was the duty of the tribunal to decide in this proceeding whether there was an insurance policy or not?
On this issue, there is a judgment of Honorable Supreme Court 2019.
Yes, show me.
I have it in mind. I just say the citation. That says that in the same proceeding, they don't need to initiate a separate proceeding for recovery. In the same proceeding, they can.
For a recovery. Now, it has in the proceeding, it has to be decided whether there was a first. It has to be decided whether there is a valid existing insurance policy or not. Who will decide?
That issue.
In which proceeding it will be decided?
For that issue, I am the claimant. I am for claimant.
I am asking you. Your claim will not be hampered by this order. Just tell me. Was it not the duty of the tribunal to come to a conclusive finding whether there was a tribunal or whether there was a valid existing insurance policy or not?
No, it was the duty, and from the record it seems
So had the tribunal discharged this duty?
that is admittedly you are absolutely right. No, that is there. But the point of law is that the subsequent cancellation of policy would not affect the right of a third party.
So where is that finding? So he is on the point of recovery.
He should be given.
Now question is why he should be given? On what basis he should be given? The tribunal has not found, tribunal has not even given a finding whether the vehicle was properly insured or not.
That is their plea, and there is nothing contrary to suggest that there was a policy. They are saying that they have cancelled the policy and that they have brought on record. The only thing which they could not bring is that on which date it was cancelled, as they did not bring the cancelled governor. Owner did not appear before the court below, not even before the High Court. So to that extent, since the owner is not present, to that extent that can be claimed, but the right of third party as far as that is concerned, I earlier on the earlier occasion you heard, and I relied upon two judgments wherein it stated that subsequent cancellation of policy would not affect the right of third party.
It is. I am absolutely not on that point. I am on the point whether it was incumbent upon the tribunal to decide and come to a conclusive finding whether there was a valid existing insurance policy or not.
Since all the documents were on record, it was the duty of the tribunal to decide that.
Where are the judgments? Where is the judgment, Mr. Ghosh, where it says that the court has to decide in the same proceeding?
But that is the Swanson's case, and what the court of trial must decide all the issues at a time. It is the schedule of what is
You have 2018, volume 9, SEC, page 650.
What is it?
Sanamma versus Oriental Insurance Company.
There is no decision till date that all the issues involved in the suit will not be decided in that one.
That is CPC.
That is CPC.
That is CPC. All the issues are to be decided.
That's right.
Now, can he defer?
Even the decisions by which right of recovery has been given in a case of cancellation, those decisions are not applicable in these cases. Because in this case, the court yet to decide whether the policy was valid or not. What is the policy? Thereafter, that those decisions are taken. Of course. Sir.
Where is the evidence, documents?
Then this exhibited cancellation letter. Finally, the policy was cancelled just on the next day.
Page?
That is case matter. The exhibit internal basics of the award. Running basics. 76. Exhibit A is the letter of cancellation of the covenant, though it has been mentioned that the original covenant was cancelled, and apparently the original covenant has not been produced by the owner, but simultaneously the same cancelled covenant has also not been produced.
So it says that as the subject matter of insurance is not insurable, no cover has been granted to you, and also please note that as no consideration has been received by us towards premium. Cover note was issued, cover note number 1974,
Yes.
dated 22/1/2022.
Right.
That means that means you have received some money. Without receiving the money, how could you issue a cover note?
I have not the exhibit, that is the evidence of 3.1. He has stated that I have not received anything. Perhaps the premium has been paid by check, and that has not been possible. And instantly the same was cancelled. Cancellation letter has been issued. For the appreciation of the fact that the vehicle was
Yes. The vehicle was an old vehicle.
1974. After 28 years, the financier came and this has happened.
No, so where is the provision that the vehicle cannot be insured?
That is 141, section 41(7). Firstly,
Section 41,
subsection 7.
This is a certificate of registration. I am asking the policy.
जो registration हम registration करा रहे हैं जो क्यों cancel किया the ground of cancellation because it is
Now you said that the vehicle is
1974 May.
so if the registration was valid, so how can you say that I will not insure the vehicle?
As per section 41, it is valid for 10 years. Thereafter, subsection 10 of the same section is for another 5 years. Total 50 years.
Now tell me, what about the vintage cars? There are vintage cars also.
Regarding that, I am not clear because there is perhaps one
The vintage cars, I am telling you, the registration of the vintage cars will not lapse.
No.
It has to be registered because it is plying on the road.
Yes.
I am telling you, I have a vintage car which is plying on the road. 1952 model Chevrolet. It is still plying on the road. It has a certificate. Under the Motor Vehicle Act, registration certificate. It is also insured. National Insurance Company has insured this car.
Whether this particular vehicle has been declared as a vintage car or not.
I am telling you, if the registration is continuing, how can you say that it cannot be? It doesn't say that a vehicle of 15 years old it cannot be insured.
That right has not been provided given to the insurance company.
Some extra charges are there, but it can be registered.
Regarding
It's admittedly his vehicle was registered.
yes.
It has a registration certificate. Then how can you say that I will not insure? Because
directing rules.
Because you cannot say that the vehicle, these old vehicles, which are in fact classic or this vintage, they should be scrapped. There is a policy of vintage cars also. This vehicle is of the year 1972. 74. So it's nearly 48 years.
No, 28.
At the relevant time.
No, rather relevant time of accident. So it only says it's 15 plus 5. No, this 15 plus 5. This was incorporated when? This 15 plus 5. '94. When did the accident take place?
2002.
2002.
27.
Where is the 5 year? What is 56? But in this case, a cover note was issued, which is apparent from this exhibit itself.
Yes.
Section 41 subclause 7 says,
Yes.
a certificate of location issued under subsection 3, whether before or after the commencement of this act, in respect of motor vehicle other than a transport vehicle, shall be subject to provision containing that be valid for a period of 15 years from the date of issuance of such certificate and shall be renewable. The last section subclause 7, 14 shall be renewable.
So the vehicle met with an accident very next day, after 2 days.
After 2 days. On 27th, on 22nd, the insurance cover note was issued. On 27th, accident took place.
22nd, the cover note was issued. 27th, the accident.
After 2 days. The issue not here is, if I kindly appreciate, the issue here is it revolves around the cover note, which is the main document which the insurance company is duty bound to produce, which neither they have produced nor they have proved that it was delivered to the owner of the vehicle, which is necessary. Because even if they dispatch and it doesn't get delivered before accident, even their third party right cannot be affected. So they have to prove that it was actually delivered, the cancellation covered note to the owner of the vehicle. Neither they produce that it was cancelled on 23rd, nor they are able to prove that it was delivered to the owner of the vehicle, that cancelled cover note. This letter exhibit A is their internal document law.
Policy or a cover note is cancelled by not by making a separate endorsement, but is by a separate letter, and that is the
Cover note has not been produced only, and that is the main finding by the court.
Subject to my lord, if the owner book of the vehicle comes, my lord.
No, how can now?
But that is the expired against the.
What is exhibit 4?
Exhibit 4.
This was the photocopy.
Postmortem report and insurance
No,
policy.
no, exhibit 4.
Insurance policy.
That's it.
3 is postmortem, 4 is insurance policy.
This policy was also issued.
Policy was also issued. And the owner did not come to defend, so the court said that if that is open, the court should not have done before the
Where is the registration document? Document of registration of the vehicle? You have not brought on record.
But whether the work of the
Doctor was not able to affiliate the ticket, and Mr. Karabi, the registration number is also not in dispute. BHT 5389 is also not in dispute.
Because I have a photocopy of the registration book, but from it is appearing that registration revalidated thereafter up to on the up to column 1/5/1999.
1/5/19. Thereafter, it has not been revalidated.
Then for minus to the one.
Hear this? It will be on the list.
In this case, there are actually nothing has been paid till date.
Yes, Mr. Ashutosh Anand.
In this case, I want to take that line. There was a way of our law. I won't say much. I indicated to the department.
Where is the file? Where is the file?
Please just.
215. We have.